everyone, I'm Stephen Darby, an associate here at Ward & Berry, and I'm going to talk about what I mentioned last time, and that's the case of Henderson Road Restaurant Systems, Inc. versus Zurich American Insurance Company. And I'll stick with Henderson and Zurich as their names. Now, this case was interesting because Henderson was a chain of restaurants which shut down due to the government closure orders surrounding COVID-19. And they had an insurance policy with Zurich that had a virus exclusion clause, and you'll see a couple of different names for these clauses. In this case, it was called a microorganism exclusion clause, and there's no real tangible difference except for the name. It still smells of exclusion. So, on Henderson's motion for summary judgment, they claimed that the policy was ambiguous and it had conflicting language. And when a policy is ambiguous or it has conflicting language, it will be construed against the drafter of the policy, which was Zurich in this case, and typically is the insurance company. And the ambiguity arose because the policy also included that losses would be covered from loss of business income from a suspension of operations that was caused by the direct physical loss of the property. Now, the policy also covered losses of business income for direct physical loss to the property. So you're probably wondering why these two clauses have essentially the same language except for the different preposition of versus to. And because if you have a direct physical loss to the property, that seems to insinuate that something has happened to the property, that it's been damaged in some way. Whereas a direct physical loss of the property seems to insinuate that you just can't access the property. And Zurich argued that the virus exclusion clause applied despite the ambiguous language. But the policyholder took a tack that's actually opposite of some of the claims right now in this space, and they argued that they never even claimed COVID-19 was present at all on its properties. And this is different than a lot of the claims that we're seeing because direct physical loss to the property clauses are kind of requiring policyholders to argue that COVID-19 is physically present on the property. Something happened to the property. And the plaintiff here didn't have that concern because of the word of. Zurich had also included a loss of use exclusion for this policy, which would have essentially completely negated the loss of business income clause. And because that was ambiguous at best, the court ruled for summary judgment in the policyholder's favor. And the court essentially found that of was a very important word because the direct physical loss of the property is not the direct physical loss to the property. And I think this is a very good example of why reading every clause and every word in the clause is so important when purchasing insurance. A simple phrasing issue allowed this policyholder to not only recover under its policy, but also to avoid a trial altogether, minimizing its legal costs. But I need to emphasize that this result won't be binding on a lot of courts. Even though this case was in federal court, this is a rule based on Ohio law. As I noted last time, insurance is governed by state law, so even in federal court, the courts have to follow state law when ruling on these cases. And that's why forum selection can be so important. So next Tuesday, I'm going to discuss the importance of forum selection using California federal and state courts as an example. And I'll also touch on what the federal courts are doing when the state Supreme Courts haven't decided on these issues. So I'll see you next Tuesday. Thanks for tuning in.